Well, thank you, Daniel. Welcome to the South Center. As you may know, the South Center is an intergovernmental organization formed by 57 developing countries around the world. For today's meeting, we have an excellent panel to discuss about exploring synergies in multilateralism and human rights for a just, fair, and equitable recovery from COVID-19. Without any further explanation, I will pass the micro to the Executive Director of the South Center, Dr. Carlos Correa, for his introductory remarks. Professor Correa, you have the floor.
Well, thank you very much, Fernando. So be welcome to this webinar. Thank you to the distinguished panelists and also to our participants for joining us. So this discussion is very important in relation to an initiative from developing countries, in particular, as you may recall, it was South Africa and Ecuador that originally submitted the initiative in order to develop a legally binding instrument on transnational corporations and other businesses and human rights. But interestingly, the discussion about the role of transnational corporations and how to discipline their conduct started many years ago, at least 40 years ago. Interestingly, the United Nations established a center on transnational corporations that functioned in New York. And there was a negotiation on a code of conduct on transnational corporations in the 70s and part of 80s that finally failed because there was no consensus in order to move into an international instrument. But this means that the role of transnational corporations and the way in which they may impact the economies and society has been on the international agenda for quite a long time. But since this debate started 40 years ago or so, transnational corporations grew in their economic importance, in size, in geographical scope. New transnational corporations emerged, for instance, now in the digital economy. And also transnational corporations became more sophisticated in dealing with national regulations, in avoiding taxation, as it is the case in many developing countries, in avoiding liabilities, and also in avoiding liabilities in particular in case of violations of human rights. So that's why in 2014, this proposal to develop a legally binding instrument was done. This was Resolution 26-9, which established an open-ended intergovernmental working group with the mandate of elaborating a legally binding instrument. So the mandate of this open working group is very clear. It's not just to debate about the impact of the operation of transnational corporations and the chain of suppliers they may have on human rights, but it is to end up with a legally binding instrument. So now we are very close to the 7th session of this open-ended working group, in which a 3rd draft will be under discussion. So now we are entering a very important phase of text-based negotiations. There have been a lot of inputs already that have been considered in the new draft. And then this may be a very important time in order to move forward the discussion and adoption, hopefully not in a too far time of this legally binding instrument. In fact, this process may be accelerated on the basis of the establishment of a group of friends of the chair that will help with the process intersessionally. So this may also be an important instrument, and this will be announced, as far as I understand, after the seventh meeting. But let me highlight some of the features of this process. In the first place, this process has been open. Really open for discussions. So it has been very transparent. There has been wide possibility for civil society to participate in discussions and to make submissions. Experts were invited, Professor Durias Seva, for instance, was invited on several times in order to make presentations on particular issues. The process itself of negotiating this legally binding instrument is important in terms that is helping to create awareness about the need to address the conduct of transnational corporations and other businesses. Interestingly, in the few last year, there have been some interesting developments in some countries, such as in France, in Germany, in relation to the adoption of legislation on due diligence. There are also some developments in United Kingdom, in Australia. This is important because these countries host transnational corporations and other big companies. And therefore, this is maybe is not a reflection of discussion that are taking place in the working group, but it's a positive development in terms of addressing the problems, in particular, the problem of jurisdiction when violations take place in one country and there is no possibility to get remedies in such a country. The new draft, which is submitted for discussion, contains a number of new elements as compared to the previous draft. I will not refer to this. There are some important issues, including the strengthening of the due diligence requirements and also some clarification of definitions. So let's hope that this new draft will help to move forward the negotiations. And certainly the South Center is very much committed in supporting the exercise. And we will continue to organize consultations as necessary, and will support the chair and rapporteur to the extent possible, in order to ensure that the final objective is reached, the adoption of the legally binding instrument. Thank you very much.
Thank you, Professor Correa, for your remarks and also for putting us in context. Now, I am very pleased to introduce our first speaker, Professor Surya Deva. Professor Surya Deva is professor at the Macquarie Law School, University of Macquarie, Sydney. He researches in the areas of business and human rights, international human rights law, and sustainable development. Professor Deva has published extensively in these areas and has advised UN agencies, governments, multinational corporations, and civil society organizations on issues related to business and human rights. Prior to joining to Macquarie University, he taught at City University of Hong Kong, the University of Delhi, and the National Law Institute, University Bhopal. Professor Surya, the floor is yours.
Thank you very much, Fernando. I hope all of you can hear me. And let me start by thanking the South Center for organizing this webinar on an important issue and extending the invitation to me. This is very much welcome, and I'm looking forward to sharing my thoughts and having this dialogue. So I have been asked to speak about how this proposed legally binding instrument can engage or regulate international financial institutions. So my remarks would focus on that, but I'll be happy to deal with wider questions, perhaps during the discussion time. Before I deal with international financial institutions, let me start with the post-pandemic world and the governance lessons that it throws before us. I think that will be my starting point. So the pandemic has shown that there are very deep-rooted inequalities in our society. There are estimates that about 150 million people are likely to be pushed into extreme poverty because of the pandemic. For the first time in last 20 years, the number of child labor has increased in the world. And of course, we have seen increased number of gender-based violence and domestic violence cases. In many of those situations, women are disproportionately impacted. So I'm giving these examples to show that these inequalities had existed in our societies, but we were ignoring them. And the pandemic has really exposed those inequalities, which have been very, very pervasive and deep-rooted. The pandemic has also shown, in my view, how fragile is our system, because the supply chains were disrupted, the travel has been disrupted, and the economies have been shattered, especially certain economies, if they are over relying on one particular sector. Let us say there are certain countries who were relying on tourism for the economy predominantly. And if there is no tourist coming, then the economy of those countries are suffering. On the other hand, if certain countries are relying on exclusively on supply chains, either to import or just to export, and that was the main source, that has also been impacted. Thirdly, the pandemic has shown how much dependent we are on corporations. Let us take the question of vaccines. Now, who are manufacturing vaccines? In almost all cases, these are companies. They could be state-owned enterprises or private companies. In some cases, there has been significant public funding given to these initiatives in terms of development and innovation, but ultimately corporate actors are involved. And if we have unequitable or unfair distribution of vaccines, then it raises serious questions in my view about the responsibilities of the manufacturers of vaccines, the private sector once again. So I think that is the starting point, that these are the issues that have been exposed by the pandemic. And that's why we have to learn certain lessons in terms of the global governance, in my view. The first lesson, in my view, is that the free market economy is not really working for everyone. When SDGs are talking about leaving no one behind, that is not happening in reality, because free market economy is free only for certain elites, those who can enter the market. The poor are not even able to enter the market, so it's not free for them. They are excluded from the privileges of the free market economy or the globalization that is there. So it's not working for everyone. That's a very clear lesson that the pandemic has shown us. Second, I would say is that the state regulation is critical. We should not see voluntary versus mandatory regulation as in competition. We need both. But it is absolutely vital to underline the point that unless states regulate effectively, voluntary initiatives don't function well as well. So you need binding rules, and then the voluntary initiatives can work under the shadow of binding rules. And then this ecosystem works better, in my view, rather than the other way around, where the voluntary systems are the dominating force of regulation. My third lesson I would suggest is that it is not enough if states regulate individually. States have to act collectively. And I think that is the context within which we should be looking at this legally binding instrument process, in my view. Because if we are talking about climate change, or we are talking about new technologies, these are the challenges, or even COVID crisis. These are the challenges states alone cannot grapple with. So of course, states have to act, but they have to act collectively. And the recent agreement that has been reached about taxation, minimum taxation about the corporations, is an example of that, that you need that collective action. Otherwise, companies are able to trigger races to the bottom. So states have to see that it is in their interest to regulate collectively the corporate behavior. Otherwise, corporations do divide and rule policy, and they bargain and try to push certain countries to lower their standards in exchange of foreign investment promises. And in the long run, that backfires. So we should not see this anymore as a North versus South issue, in my view, because we have significant number of corporations even from the global South. And the activities of corporations will pinch, and already pinching, in my view, even the global North countries. So it should not be seen that it is a typical 1970s situation of the North versus South dynamic, in my view. So that is the overarching context within which I wanted to situate now the specific discussion about the international financial institutions. Now, if you look at Article 3.1 of the third revised draft, it talks about regulating business activities once again. So because if you look at the second revised draft, it was talking about corporations, business enterprises and all that. But now it's not talking about business enterprises, it's talking about business activities. And I guess this is again because of this divide. Should it regulate only TNCs or should it regulate all? So to bypass this debate, it is focusing on business activities. This may look okay, but the real difficulty is when it comes to liability in subsequent provisions, you don't impose liability on business activities. You have to impose liability on the actors. So you can't really bypass this issue, even if you put it here as business activities. But that is besides the point. Now, what is meant by business activities? That is defined by Article 1.3. And what is crucial for our purpose today is that it uses for the first time, in my view, the term financial institutions. So this term financial institutions is mentioned as part of this Article 1.3, and that raises the question whether it tries to capture even international financial institutions. I think it is ambiguous. Perhaps it does not cover international financial institutions. Perhaps that is not the intention. That's my reading at least. But it definitely creates that possibility that whether this proposed legally binding instrument will apply to international financial institutions, whether this is, let us say, IFC or Asian Development Bank or AIC, it could be anything, right? We have so many of these financial institutions. Now, international financial institutions, in my view, they should be regulated in relation to their activities. If their activities are causing or contributing to adverse impact on human rights or the environment or climate change going forward. And it triggers two aspects, in my view. One is the role of the states, because these financial institutions are created by states collectively. So when states create something, they cannot just ignore their international human rights obligations. States cannot ignore that. You cannot merely outsource your obligations by creating something like this. So I think that is one element of it. The second is that even international financial institutions, they in their own way should have responsibilities and obligations, in my view. And I think we can derive this also from UN guiding principles, but we don't need to rely merely on UN guiding principles. We can also derive it from international human rights law, in my view. Now, let us look at very quickly the practice of international financial institutions that is relevant. Now, if you look at almost all international financial institutions, they have some kind of sustainability or social impact or environmental impact assessment policies and practices in place. When they're funding projects, they're providing loan for any project, normally they have some kind of a due diligence process, whatever they call it. That's first element. Secondly, most of these institutions have their internal system of accepting complaints. Whether that is effective or not is a separate point. But they have some kind of independent accountability mechanism which can provide some mediation in some cases, but it could also be more than mediation and could do some binding rulings on that. The third element that I would like to highlight is that these institutions are also expressly now engaging with climate change finance. How do you mitigate the climate change? What kind of financing is needed for that particular purpose? Because you need to finance, let us say, green technology and all that. And the element of ESG disclosure is also going to become relevant, right? So I think if you look at these emerging practices of these international financial institutions, then I think one can say, oh, this should not be difficult. If the treaty is going to impose obligations on these institutions, that will be already in line with what they're already doing. But my last point is that it may look simple, but it will be very difficult, in my view, for this instrument to effectively regulate the international financial institutions. Especially the current draft is ambiguous. It cannot really achieve that objective. For instance, if the state of a particular, let us say the government of a particular state tries to impose mandatory human rights due diligence obligation on a international financial institution which is based in that country, is it going to be bound? What about the liability provisions? Because there are, I think it's Article 8, which talks about liability. Whether the officials and that institution is going to be liable, civil, administrative, criminal liability. I very much doubt this will happen. Why? Because many of these institutions have immunity. They are not created under the domestic law of a particular country. They are created by some kind of international or inter-regional institution. So some kind of a statute is there. And if we can draw inspiration, in fact, from the litigation in the US, because there was this US Supreme Court decision involving IFC a couple of years back, I think 2019, if I remember correctly, JAM versus IFC, in which the IFC was sued in the US courts because it had funded a project which resulted in the loss of livelihood to these farmers in one of the states in India. And the case went up to the Supreme Court, and Supreme Court said, look, IFC or the World Bank, they don't have an absolute immunity. They have immunity which is restrictive. And if they deal with commercial matters, then the immunity does not apply.
Professor, sorry to interrupt you. Could you try to wrap up just in order to give the others also?
This is my last point. Thank you. This is my last point. So because of that case, I would suggest that in practice, it will be very difficult for this proposed instrument to regulate effectively international financial institutions. We need more explicit provisions if that is the ambition. The current draft, in my view, is not adequate, or perhaps we should not go in this particular direction, because if we can regulate even companies as a starting point, that will be more than enough. That is already quite ambitious. I will stop with that. Thank you very much.
Thank you very much, Professor Surya, for these very insightful comments. I think you have described many different issues on this topic, and we will come back to you perhaps in the Q&A section on some the remarks you made. Now I am going to pass to our next speaker, Mrs. Jessie Coleman. She's a senior legal researcher at CCSI. She coordinates the center's work at the intersection of human rights and investment law. She's also co-editor-in-chief of the Yearbook of International Investment Law and Policy. Prior to joining to CCSI in 2015, Jessie worked with public health and human rights organizations. Jessie holds a master on law from the University of Cambridge, where she specialized in public international law. Jessie, you have the floor.
Thank you so much, Luis. I'm very grateful to the CEST Center for inviting me to join. It's a real pleasure to be with you all today. As Luis noted, my name is Jessie Coleman. I'm a senior legal researcher at the Columbia Center on Sustainable Investment, or CCSI. Our work at the center focuses on aligning international economic governance with sustainable development, human rights organizations, and climate objectives. So the topic of today's meeting is deeply connected to our work. I hope to share three reflections or 3 points with you regarding human rights impact assessments of international economic treaties and how this issue area is or could be addressed in the context of the legally binding instrument. So first, the need for or the obligation to undertake assessments of international economic treaties as opposed to assessments of projects has been underscored by a number of human rights authorities in the past decades. And this need has been exacerbated in the context of the COVID-19 pandemic, where, as Surya noted, countries are seeking inward investment as part of economic recovery efforts and are often seeking this investment irrespective of the costs that are or may be associated with its impacts. The former UN Special Rapporteur on the Right to Food, Olivier de Schutter, put forward in 2011 guiding principles on human rights impact assessments of trade and investment treaties. And these principles were put forward not as new obligations, but as elaborating the implications of pre-existing norms and standards for states when negotiating trade and investment treaties. Similarly, General Comment 24 of the UN Committee on Economic, Social, and Cultural Rights provides that pursuant to their obligation to respect human rights, states parties should identify any potential conflict between their obligations under the covenant and under trade or investment treaties, and refrain from entering into such treaties where conflicts are found to exist. So impact assessments conducted on a regular basis are noted by the committee as being a means of identifying such conflicts. And most recently, the UN Working Group on Business and Human Rights, in its report to the UNGA on aligning investment treaties with human rights obligations, underscored the connection between protection of host state regulatory space and the carrying out of both ex ante and regular ex post impact assessments of trade and investment treaties. In the EU specifically, the Ombuds Office has criticized the European Commission for failing to carry out human rights impact assessments of economic treaties, including for failing to carry out an assessment of the EU-Vietnam FTA in 2015. And in that opinion, the ombudsperson considered that EU institutions must always consider compliance of their actions with fundamental rights and the possible impacts of measures such as economic treaties on such rights. So the LBI, the legally binding instrument, reflects the narrative, I think, that human rights authorities have advanced on this issue. Article 14, regarding consistency with international law, provides that states parties shall ensure that all existing trade and investment treaties must be interpreted and implemented in a manner that does not undermine or restrict their capacity to fulfill human rights obligations. It also provides that future treaties must be compatible with human rights obligations. Human rights impact assessments of treaties, although they are not explicitly mentioned in the instrument, provide a mechanism for complying with this provision. They are, of course, not sufficient to, by themselves, satisfy full compliance, but they do provide an avenue for reaching compliance with respect to consistency with international law. Article 6 regarding prevention is also, I think, relevant. Article 6.8, for example, provides that states parties shall protect policies and legislation relevant to the LBI from influence of commercial and other vested interests. We know that commercial interests typically have really outsized influence on economic treaty-making processes, and human rights impact assessments, if inclusive and meaningful, may provide a mechanism for countering that influence. The second point I'd like to share with you is that for many years, as you all know, there has been ongoing debate regarding how impact assessments of economic treaties can be best carried out in practice on a systematic basis and in a manner that actually changes outcomes on the ground, in particular for rights holders. We convened a workshop on this topic recently with the University of Essex, and I'd just like to share a few key questions or takeaways that participants shared, which I think are pertinent to our discussion today. So number one, when it comes to the impacts of treaties, it's really challenging to pin down exactly what it is we are seeking to assess. Are we looking to assess potential impacts of projects that might come within the scope of the treaty or of processes that the treaty might establish, Or is the assessment about looking at whether obligations contained in the treaty might conflict with existing state obligations? Or is it really all of the above? And this seems like a basic question, but it's fundamental for charting an effective path forward on impact assessments and for clarifying state obligations and holding them to account, whether through shadow assessments or otherwise. Number two, the process for implementing impact assessments of treaties needs to be inclusive, and that is, of course, fundamental. But establishing how to achieve that in practice has been really challenging, particularly given the timeline for negotiations of economic treaties is often defined by political considerations. And that makes it really challenging for an impact assessment, even when it is concluded, to actually influence the outcomes in the negotiation of a text. And number three, the potential for impact assessments to actually influence outcomes is also dependent on reforming or redesigning other elements of investment governance. So for example, one expert during that meeting we convened noted that for ex post impact assessments to really be meaningful, treaties need to include mechanisms for revision of the agreement on the basis of the outcomes of those assessments. And as we know, most investment treaties don't include this type of mechanism. These are not new issues or questions. They have been raised and re-raised frequently in the debate around human rights impact assessments of economic treaties. So perhaps it's not surprising that the uptake of these impact assessments to date has been quite limited. Such assessments of certain treaties have been undertaken by the EU, Canada, and the US. Thailand has also concluded at least one, and a human rights impact assessment of certain elements of the AFCFTA was conducted with support from OHCHR. But overall uptake has been quite limited, and the scope of assessments has also varied considerably. So this brings me to my final point, or indeed question for the group today. The LBI text provides a useful footing to continue advocating for human rights impact assessments of treaties, but knowing that we have faced challenges regarding meaningful uptake of these assessments, could the language be strengthened? And of course, the LBI text itself can only go so far in advancing uptake, but is there anything that could be strengthened in the text itself or in a protocol to make it more likely that impact assessment processes will be more meaningful and inclusive? And on this question, I wonder what could be learned from agreements like the SKZU or Aarhus agreements. Both texts contain detailed provisions regarding access rights, which are also, of course, of critical importance when thinking about how to strengthen inclusive human rights impact assessment processes. So is there potential to, for example, strengthen Article 6, 8, or 14 by incorporating elements of rights to information and participation in decision-making, or to reflect these in a protocol? And would this provide advocates and civil society with a stronger foundation to advance uptake of inclusive human rights impact assessment processes? So I'm eager. I'm wrapping up right now, so I'll finish up in 1 second. Thanks, Luis. I'm eager for your views on this, and I'll stop here and look forward to the discussion. Thanks very much.
Okay, thank you very much. The issues also you raised important. This impact assessment is quite important. Well, since we have finished the first panel, we are going to open the floor for participation from colleagues from that are participating. I know if they have questions, you can use the tab below the screen, the Q&A section, to ask questions. I don't know if we have any question right now. Danish, Daniel, would you like to take the floor now?
Thanks, Fernando. Yes, I have one particular question in my case for Professor Deva, for Surya, but there are also certain comments in the chat, both in the question and answer box and also in the chat. So I will first refer to those, and then I will ask my question if there is enough time. So in the first one, we have a comment made by Annamaria Suarez from FIAN. She's saying that impact assessment and popular consultations are very relevant, but in the current draft, they are under due diligence. While according to the experience of many cases we have analyzed at FIAN, it is key that those are on the hands of the states or impartial bodies and not in the hands of companies. The experience shows that when done by companies, impact assessment can divide, or consultations are used to divide communities. So I guess that one of the questions is, what is the particular role that the state should have when conducting impact assessments, particularly of international economic agreements? But at the same time, maybe a question would be, in those cases, which will be the role of the companies according to the legally binding instrument? Should that be clarified or not? And I think that language goes as well with the question which is raised by Claudio Schuften, which says that if it is just a stringent language which is necessary in the treaty, or there should be, it is not the powers that have to have interest in this assessment. So which one should be the one conducting the impact assessment? And then the question I have for Professor Deva is particularly with regards to the decision taken in the United States in the case of JAM. I think that one of the questions is if the legally binding instrument, by clarifying the language a little bit, would actually support other states that doesn't have the kind of power that the Supreme Court of the United States has, will be able to bring that kind of practice into their domestic legislation. So we know now that the power of the Supreme Court and the relationship that the United States has with international law has been in one way or another a little bit differentiated from those that other countries have in international experience. And at the same time, in the case of JAM, the case of JAM was related particularly to a commercial contract. So if we are going into the discussion on climate change, for example, what kind of possibility will have a country to start a case, or even to have the possibility of initiating this kind of procedures against an international financial institution if they have a contract signed between the state and the international institution itself? One of the cases, for example, could be some kind of agreement signed between the IMF and other states in the issue of debt, for example. So what will be the possibilities there to start a claim or a procedure? Thank you very much, Fernando.
Thank you, Daniel. We are going to proceed. One more question. I think it's for Professor Surya as well. From the chat box, we have the question from Wesam Ahmad. He said, do you think the legacies of colonialism and the broader process of decolonization are given enough attention in the business and human rights discourse? I think with these four questions, we are done for this section. So we are going to ask first to Jesse to answer, later afterwards, Professor Surya. Jesse, please go ahead.
Great, thanks so much. I'll just jump in on Annamaria's question, which I think is a really, really great one. I think there are sort of two key buckets of issues, one being the approach or model that's relevant for impact assessments of projects or specific investments, and then the other being the approach that should be taken or needs to be taken with respect to treaty making processes. In both cases, of course, it needs to be inclusive and focus on outcomes that need to be achieved with respect to rights holders. For projects, I think that collaborative models where power imbalances are addressed are critical, and the company should not, in my view, be the implementer for reasons that you flag in your comment. And CCSI worked with the Danish Institute for Human Rights to develop what they called a collaborative approach to human rights impact assessments, and I can share that in the chat for anyone who's interested. For impact assessments of treaties, I think, I mean, all of this is incredibly complex, but I think for impact assessments of treaties, it's even trickier to understand what the appropriate role for the state is, what the appropriate role for other stakeholders is, because you want the process to be driven by the needs and interests of rights holders, citizens, civil society. But because it is a state-driven policy-making process, they're going to have a fundamental role in driving that forward. I think the model right now where consultants in most cases carry out the impact assessment is really not in any way optimal. And we've seen that the results of these sustainability impact assessments, for example, are really not considering human rights impact in the way that they should. So this, I think, is really where a lot of the work needs to happen to understand how we can redesign that approach, whether undertaking shadow assessments, for example, to really dig into how those state-driven assessments are happening and understand how they could be reformed, whether that's an option to figure out how they could be done better. I think this is really the area that demands further reflection and work. But thank you so much for your comment and question.
Thank you, Gissi. Professor Surya,
thank you. So I will try to respond to the three questions briefly. I agree with whatever Jesse mentioned about the due diligence and the impact assessment. I also tried to respond to that question in the chat box. But I would like to make one more point. I think we should not confuse human rights due diligence by businesses with their responsibility or obligation to respect human rights. Human rights due diligence is a process. It may or it may not ensure a given outcome. And I think that is why it is absolutely vital, in my view, that the duty of a state to ensure that businesses do not abuse human rights. We should not focus merely on human rights due diligence. This is only one of the tools, but there could be other tools. For instance, there could be a provision for a strict liability in certain cases, right? So there could be precautionary principle that could be applied in some other situations, right? So I think we should be mindful of this distinction between process and outcome. Now, in terms of the, Daniel, your question about the JAM decision in the Supreme Court, yes, I think that decision is perhaps a positive decision on paper. But if you look at the practice and reality, the Supreme Court sent the case back to the lower court on remand to hear it again. And the lower court again dismissed the case, said that the immunity still applies because the commercial decision was not made in the US. Rather, it was made in India, where the plant was developed. So even if the funding is provided from Washington, DC, that is not the real thing. So what I'm trying to show is that there are always those limitations in practice. So, and I think different jurisdictions and different courts may not be even going as far as the US Supreme Court has gone in the JAM case, that there is no absolute immunity. I'm aware of certain jurisdictions, they will say, oh, there's a complete immunity. Moreover, if the statute of international institutions provide for absolute immunity, the domestic courts are likely to respect that. Because in the case of World Bank and IFC, the statute was not very clear on the absolute liability, absolute immunity, and that's why the court had this room for interpretation. So what I'm hinting is that I agree with the goal that international finance institutions must be obligated to ensure that their projects do not result in abuses of human rights. So I agree with that goal, but I am skeptical whether this binding instrument, at least in the current form, can achieve that goal. Now, finally, very briefly, colonization, decolonization question. I don't think this treaty process or the draft deals with colonization or decolonization. I think that is a separate project in my view, because still I think this is a politically sensitive issue and many states would not like those issues to be discussed as part of a treaty making process, because it's already very polarized issue, global north and south. And if you throw in colonization and decolonization, I think this is going to become a hot potato in my view. So I think that point is valid, but I think we have to be aware that what this treaty can achieve and what is politically feasible. and what is a debate, academic debate and discussion and advocacy, which is very legitimate. Thank you.
Thank you very much, Professor Surya. So we can come back to some questions at the end of the presentations. We are going to start now with the second panel. Our first speaker is Ms. Manja Bayan. She's an indigenous person, a human rights lawyer with 2 decades of activism and advocacy on indigenous people's rights. And he has been extensively engaged in the discourse of business and human rights. She assisted the work of the UN Special Rapporteur on the Rights of Indigenous Peoples from 2015 to 2020. Her work experience includes program management and coordination, research, advocacy, and capacity building. Madam Manja, you have the floor.
Thank you for this opportunity to engage in the conversation with you about the third draft of the binding instrument on corporations and human rights. I speak as an indigenous person who have met communities and hundreds of families displaced from their homes and seen the extent of pollution on resources and destruction of biodiversity and the environment, and the adverse impact on health, all in the context of business activities. These are often conducted without the free, prior, and informed consent of indigenous communities, or without consultation or participation of all affected communities. I also speak as a lawyer who handled cases of criminalization of indigenous peoples who are merely exercising their rights and defending their territories. I have covered, documented, and reported on many other forms of human rights violations like extrajudicial killings, enforced disappearances, torture, arbitrary arrests, libel, and many more, also in the context of business activities, and most often due to their opposition to the entry or continued operation of corporations that are destructive of the environment and that deny them of their control, management, and ownership of their territories and resources. I also represent the only indigenous-led international organization, the Indigenous Peoples' Rights International, that has documented a global trend of worsening situations of indigenous peoples and rights violations during the time of the COVID-19 pandemic. While indigenous peoples continued to suffer from displacement, killings, criminalization, and violence during the pandemic, it was business as usual for corporations. And worse, government regulations like lockdowns prevented indigenous peoples from exercising their rights and protecting their territories and resources. And even worse, those whose lives were under threat could not even seek sanctuary because of the restrictions on mobility. Even the rollout of aid and vaccination during the pandemic have seen marginalization and discrimination of indigenous peoples. In many countries of the global south, corporate capture is strongly felt. Transnational corporations wield more economic and even political power than the governments. Yet, as non-state actors, these businesses are exempt from legal obligations and accountability mechanisms under international human rights law. At the same time, international investment agreements even afford rights to them that are above national law and against which there is no recourse for appeal. These are among the reasons why we strongly support the process to elaborate a binding instrument. And some would argue that we already have the UN guiding principles on business and human rights. However, 10 years since the adoption of the UNGPs, evidence show that there are still many gaps in the implementation of the guidelines. Far from decreasing over the last decade, the adverse impact of business operations on indigenous peoples and their territories continues to be critical and in some contexts has even become more severe. This is evidenced in most working group country visit reports to different regions of the globe in which indigenous peoples live. An international binding instrument is therefore necessary to have a stronger instrument to regulate business operations in relation to human rights. We welcome the third draft and we observed how it has evolved from merely mentioning indigenous peoples in a list of vulnerable groups in the zero draft to including it in its preamble, the UN Declaration on the Rights of Indigenous Peoples and ILO conventions, and elaborating in the articles that consultation with indigenous peoples demands the standards of free, prior, and informed consent provided in international law. However, the third draft remains lacking in protecting indigenous peoples' rights and defenders. It needs to include provisions to safeguard the substantive rights, especially the right to self-determination, the right to own, control, and manage lands, territories, and resources. The international standard of free, prior, and informed consent is integral to the right to self-determination and intricately connected to the right to control their territories. It is not just about getting their consent, but also respecting right to say no to business activities and the right to stop any activity that destroys the environment, that violate their rights, and the right to participate in decision-making processes at all stages on matters affecting them. This is what free, prior, and informed consent means to indigenous peoples. There is an additional call for prior consent of other affected communities, and we support that. But this should not be confused or mixed with the right of indigenous peoples to free, prior, informed consent. Separate articles should be drawn on this. In addition to this, we observe that the draft, while trying to protect human rights, fails to ensure that Mother Earth is not further destroyed or plundered, or that environmental impacts are strictly mitigated, if not totally prevented. We believe in the intergenerational responsibility to protect Mother Earth, the environment, the biodiversity, and the resources, all for the next generation. If we fail in this obligation, we deny life to the next generations. In addition, the proposed treaty should include provisions to respect the environmental governance and traditional resource management of indigenous peoples, to respect the right to maintain and strengthen their distinct political, legal, economic, social, and cultural rights, institutions, and in so doing, by recognizing indigenous customary laws as part of applicable laws and traditional justice systems under access to remedy and adjudicative jurisdiction. The draft treaty can also be further developed to safeguard indigenous peoples and rights defenders against criminalization, violence, and impunity. The UN Special Rapporteur on the Rights of Indigenous Peoples reported that the intensified competition over natural resources led by private companies, at times with government complicity, has placed indigenous communities seeking to protect their traditional lands at the forefront as targets of persecution and violence. These attacks undermine indigenous peoples' ability to effectively assert their rights and protect their lands, territories, and resources from destructive business activities. The proposed treaty needs to include provisions against laws and policies that undermine the full exercise of human rights and protect rights defenders, including prohibition of strategic litigation against political participation. It must also ensure that all affected communities and individuals have full and unrestricted access to justice without threat of retaliation or violence. We will have more detailed analysis of this draft treaty, which we will be submitting in the coming days along with other organizations. But we would like also to stress our willingness to engage in dialogue or conversations with states or with other stakeholders to further elaborate our positions. And as peoples who have historically lost their lands and resources, sacrificed lives and fundamental freedoms due to business activities,
Manja, could you wrap up 1 minute to finish?
Yeah, less than that. We reiterate our support to the drafting of the binding instrument as a measure to strengthen states and business accountability and prevent rights violations. And at the same time, we call on stronger textual provisions to realize the full respect of indigenous people rights in accordance with the UN Declaration on the Rights of Indigenous Peoples. And we will not accept an international instrument that falls short of these demands, and we will not stop to engage until our calls are heard and considered. Thank you.
Very much, Manja. I think indigenous people's elements for this instrument are very important, and I think they are going to be taken into account for, in particular, the colleagues from countries that are participating delegates. Okay, our next speaker is Erika Mendez. She's a social and environmental activist and member of Justicia Ambiental, Friends of Earth Mozambique, where she coordinates the corporate impunity and human rights area. Erika Mendez is also the regional coordinator for Africa of the Economic Justice Resisting Neoliberalism program and at Friends of the Earth International, the world's largest environmental grassroots organization. Erika has been working on the UN binding treaty process for the past 6 years and coordinating an informal network of more than 40 organizations, movements, NGOs, faith-based organizations, and networks in Africa demanding a UN binding treaty on transnational corporations and human rights. Erika, you have the floor.
Thank you very much. And thank you for the opportunity to be part of this important panel. So I will be starting with some general comments and then looking a bit at the third revised draft. So starting from where I stand in Mozambique, we have been working with a lot of legal cases against some of the most powerful transnational corporations operating across the globe that operate through subsidiaries in our country and so many other countries in Africa. There are widespread violations, abuses, destruction of the environment. We have strong evidence of these violations. We have people from the communities affected willing to testify in court. We have even a progressive constitution and some very strong national legislations. We have some good lawyers willing to take on some of the cases, but still cases targeting the impunity of transnational corporations or their subsidiaries get dragged for years. In the very few cases where our national courts actually ruled in favor of the affected peoples, the companies still ignored the deadlines to provide reparations. They still took more than double the time, for example, to resettle communities that were still living inside the coal mine, less than 1 kilometer away from the explosions. And there were no compensation for health impacts from people dying from polluted water sources, for living 1 kilometer away from the mine. And they are still facing brutal repression and violence from the police, from the military, for being outspoken about the impacts of TNCs or for participating in protests and manifestations, which are allowed by our constitution. So talking about Mozambique in particularly, but I could really be talking about almost every country in Africa who has been pushed into a model of development that is based on attracting foreign direct investment, and in particular extractive industries and infrastructure mega projects, and that now are needing to face our own internal fragilities, most of them related to colonialism and wars, and now the economic recession brought by the pandemic and other crises. And at the same time, having to deal with the overwhelming power of these corporations that are able to capture our democratic spaces, political elites, and erode the state's ability to advance on a sustainable and people-centered path towards development. We have been coordinating the work of African organizations working around corporate accountability across Africa, and the pattern of reckless behavior and impunity that we witness is happening across the continent. And it alerts us that this is not a problem that can be solved with national or even regional legislation, and that will not be deterred by soft law or voluntary guidelines. We need to fill the existing regulatory gap at international level that really allows these transnational corporations to violate human rights. And this gap needs to be filled with an adequate, strong, and effective human rights international treaty that is binding and enforceable. The importance of this process can really not be overemphasized from an African perspective or from a Southern perspective. Last week, we organized an African regional consultation on the third revised draft. I will bring some of the ideas that were discussed there and a few others in the few minutes that I've left. I also invite all the presents in case you want to look in more detail. I can share the link of this consultation. So my point here will not only be that there are many necessary ways to improve the existing draft and that we should actively use the 7th session for that purpose, but also that it is mainly the people of the South, social movements alongside Southern progressive human rights oriented governments to truly define what are the structural problems in our legal system that need to be filled with this instrument. And I need to remind everyone that we are in an open-ended process, meaning that we need to continue until we have a strong and effective treaty. We don't have a deadline for this treaty. Of course, we have the urgency of having a strong and effective instrument, but we shall not accept any treaty that really doesn't change the status quo. So moving on to the third revised draft, we note that this new draft does not really bring substantial changes when compared to the previous version. Most of the changes are on the format and language. Some of them are really cosmetic changes and not oriented to improving the treaty text from the point of view of efficacy in ensuring that TNCs respect human rights. Loopholes and escape routes that have been highlighted in many of the previous sessions have not been properly addressed or even not addressed at all. And these loopholes make this text highly insufficient to meet the objective established in 2014. So this emptying of core elements of the treaty gradually across the last years is particularly concerning, especially if we take into account the very substantial contributions that have been made during the sessions, mostly from states in the South and from social movements from across the whole planet. And these suggestions could really improve the draft. Another point is that this draft goes even further away from the elements paper published by Ecuador in 2017. For example, the scope of the treaty continues to be broad, and even the suggestion to establish an international tribunal as an enforcement mechanism has never been really looked up into. There's also a need to move beyond the UNGPs and voluntary guidelines, given their proven ineffectiveness to deal with corporate power and corporate impunity. So the current draft still does not address key issues that influence the impunity of transnational corporations, such as the ability of these private actors to capture states, the huge asymmetries of power between states and the TNCs that they try to regulate, or the complexity of today's global production chains. So going a bit into the aspects around legal liability, which are one of the central aspects of the treaty, we believe that first, the whole of the Article 8 should be modified to include the violations committed by legal persons outside the territory through their global production chains. So it is also necessary to list the obligations of the TNCs. So we can see that this draft is still very state-centered. It mentions obligations in the preamble, and this has been requested by some states, some African states in particular, and many social movements and civil society groups in all of the previous sessions. But the third revised draft does not explicitly define what these obligations would be. So it's still relying on states to define them. So we believe that a last paragraph to establish TNC's obligations and responsibilities should be added on Article 8. These obligations shall exist independently of the legal framework in force in the home or host state of the TNC. The draft also contains some conflicting or contradictory parts that also ensure loopholes that are up to the interpretation of judges and lawyers. For example, on Article 8.7, it says that human rights due diligence shall not automatically absolve a legal or natural person conducting business activities from liability for causing or contributing to human rights abuses or failing to prevent such abuses. Then the second part of the same article, the second paragraph, says that the court or other competent authority will decide the liability of such legal or natural persons after an examination of compliance with applicable human rights due diligence standards. So the second part of the progress opens, again, the issue of liability to be decided by the court based on examination of compliance. So in our opinion, this second part needs to be deleted.
Erika, sorry to interrupt you, but could you wrap up in 1 minute?
Yes, 1 minute, that's fine, thank you. We also need a key provision in Article 8, establishing the joint responsibility of the different companies participating in the violation of human rights. We still don't have a proper enforcement mechanism, and we have been proposing an international tribunal, and the treaty draft still does not ensure the primacy of human rights over any other international legal instruments, in particular over trade and investment agreements. So I will end with a quote from Martin Luther King, when it says that morality cannot be legislated, but behavior can be regulated. Judicial decrees may not change the heart, but they can restrain the heartless. This quote was read by Maria Fernanda Espinosa, that was chair of the IGWG, during the second session of negotiations in 2016. So perhaps we need to retrieve some of the important elements that we had back then to ensure that the future legally binding instrument corresponds to the important mandate established by the resolution. Thank you very much.
Gracias, gracias, Erika. Ahora voy a hablar en mi idioma materno, porque nuestro siguiente orador es profesor Iván Antonio González Alvarado. Ustedes tienen la opción de interpretación en la base de la pantalla. Profesor Iván Antonio González Alvarado es profesor de Ciencias Sociales, mención en Historia, es coordinador político de la Confederación Sindical de Trabajadores y Trabajadoras de las Américas, formación en el Sistema Internacional de Protección en Derechos Humanos y especialista en temas de libertad sindical en América Latina y el Caribe. Profesor González tiene amplia experiencia en procesos de formación, organización y acción sindical en temas de derechos humanos, trabajo y medio ambiente, integración, empresas transnacionales y migraciones. Él ha participado en procesos de negociación y formulación política para la creación de la Confederación Sindical de Trabajadoras de las Américas. Profesor González, usted tiene la palabra.
Muchas gracias, profesor Fernando, y agradecer la invitación del Centro Sur y la oportunidad de expresar nuestras contribuciones como organizaciones sindicales de las Américas y también como parte de la campaña global para reclamar la soberanía de los pueblos, desmantelar el poder de las corporaciones y poner fin a la impunidad. Como ya lo han dicho mis colegas, mis compañeras Erika y Manja, sobre las definiciones y alcance de este tercer borrador, lamentablemente tenemos el resultado, lo que estamos viendo es que carece de sólidos mecanismos para garantizar que las empresas transnacionales respeten los derechos humanos a lo largo de sus cadenas globales de producción. En el borrador actual se sigue eludiendo el establecimiento de claras responsabilidades directas de las empresas. El borrador se limita al reconocimiento de una obligación de respeto, lo cual es, a nuestro modo de ver, insuficiente, adjudicando nuevamente las mismas funciones a los estados cuando se reconocemos, sobre todo en el sur, que la mayoría de nuestros estados y las jurisdicciones del ámbito nacional carecen de capacidad jurídica administrativa necesaria para proteger adecuadamente a las personas, a los colectivos y a las comunidades frente a la acción de las empresas transnacionales. Para nosotros, la lucha contra la impunidad de las empresas transnacionales exige una actuación a nivel internacional y dentro del marco del derecho internacional de los derechos humanos. Entendemos desde la CCA que como más pertinente en lo que tiene que ver con el ámbito de la definición del tratado, referirnos directamente a empresas transnacionales que a actividades comerciales de carácter transnacional, tal como aparece reflejado ahora en el tercer borrador. Para nosotros esto es un eufemismo, más que una denominación jurídica, puesto que coloca un sujeto pasivo respecto a las obligaciones de derechos humanos. Además, esta observación terminológica contenida en el tratado, en el tercer borrador, para definirse a una actividad transnacional como parte sustantiva de la preparación, control y fabricación, almacenamiento y sus efectos significativos tienen una denominación vaga en términos de la definición de sustantivo y significativo, por lo tanto deja un campo abierto a la interpretación y a la discriminación judicial. Nos preguntamos, ¿cuál es el peso? ¿Cómo se mide lo sustantivo significativo? No debería ser determinante que por sí las actividades comerciales sean causa de violación de los derechos humanos sin importar una consideración de sustantiva o significativa. Si nos parece que estos términos son ambiguos y nos llevan a una discusión y a una disputa muy peligrosa respecto a la naturaleza real de la responsabilidad de las empresas. También, desde el punto de vista de la visión del sindicalismo de la región, nos resulta decepcionante que en este tercer borrador desaparezca la consideración de las cadenas globales de producción o de valor como ámbito de consideración del tratado. Las empresas transnacionales, la visión sindical, se centran su ganancia y el lucro especialmente en la falta de protección de los colectivos de trabajo y trabajadoras a lo largo de las cadenas de producción, a través de formas de contratación que son muchas veces ficticias, a través de la utilización de tercerizaciones, a través de la externalización de la actividad difuminada en los territorios, en los países, donde la mayoría de las veces no hay responsabilidad directa de las empresas. Para nosotros, este tema de las cadenas globales de producción debe ser un asunto central respecto de la aspiración de un tratado vinculante. El otro elemento que nos parece importante tiene que ver con sobre la obligación respecto del cumplimiento de los derechos humanos referido en el artículo 3.3 de este presente borrador. El artículo circunscribe el cumplimiento de los derechos humanos a la existencia de ratificación previa de los instrumentos internacionales concernidos por los estados. Y esto figura, es una limitación por cuanto sabemos que muchos instrumentos internacionales, incluyendo los que protegen los derechos del trabajo, no requieren de una ratificación para ser reivindicados como tales. En consecuencia, nos parece que este término vinculante referido a la suscripción, a la firma de los instrumentos internacionales de derechos humanos puede ser una limitante. Por otro lado, tenemos avances en la declaración del centenario de la OIT, como por ejemplo, cuando se refiere a la necesidad de incorporar otros derechos fundamentales como la salud, la seguridad del trabajo, el salario mínimo y la duración de la jornada de trabajo como parte de lo que llamamos la Declaración de Derechos Fundamentales. Entonces, en este sentido, creemos que el tratado debe incorporar también esta valoración de la OIT en relación a los derechos fundamentales del 98. Y queremos referirnos muy rápidamente a lo que tiene que ver con la responsabilidad de las empresas y lo que es la consideración de la debida diligencia. Ya anteriormente hemos sido críticos respecto del exagerado acento que se coloca en la obligación de debida diligencia, ya que, como lo ha dicho el profesor Surya, constituye una regla que no asegura un resultado final de cumplimiento de los derechos humanos, sino un mero mecanismo de proceso. Informar, prevenir, vigilar, lo que claramente no lo coloca como una obligación de medios y no como un fin efectivamente que comprometa a las empresas transnacionales en la garantía de los derechos y en la responsabilidad que tienen sobre su violación. La debilidad de la solución propuesta por el borrador radica en que si bien es compatible que no se consagre la exoneración de la responsabilidad automática, en el cumplimiento de la medida de prevención, de todos modos la empresa transnacional puede ser absuelta de su responsabilidad si un tribunal o otra autoridad considera que cumplió con la debida diligencia. Esto podría significar que al final, dependiendo del abordaje del punto de vista jurídico de los tribunales, que en muchos de los casos en nuestros países, por lo menos del sur global, son débiles, puede simplemente la empresa desentenderse al valorarse que cumplió con la debida diligencia, pero en el fondo no se responsabiliza por la violación de los derechos ocurridos a lo largo de su cadena global de producción. En este sentido, se requiere un grado de responsabilidad de la empresa principal y que tiene una responsabilidad de tipo solidario y objetivo, que garantice la prevención y eventualmente la reparación de los daños, pero que también la obligue a ser sancionada o la lleve a una sanción a partir de la violación de los derechos. Como ya lo hemos señalado desde la CCA, el problema de centrar la obligación de las empresas en una obligación de medios no focaliza la efectividad del cumplimiento de los derechos humanos que debería configurar el objetivo específico de la protección tratándose de un instrumento internacional. Para nosotros, la conducta responsable y cumplidora de los derechos humanos de las empresas debe basarse en el reconocimiento de un elenco amplio de derechos fundamentales de los trabajadores y otros derechos humanos, el cumplimiento estricto de que esos derechos humanos no se limiten solamente al deber de prevención de riesgo, la debida diligencia, y a una responsabilidad plena y objetiva de la empresa transnacional respecto de las empresas vinculadas en las distintas formas jurídicas y en las distintas expresiones a lo largo de la cadena global de producción. Finalmente, para terminar, creemos que respecto de la próxima sesión del grupo de trabajo, el involucramiento activo de los estados, especialmente los estados del sur global, es fundamental para arrogar a un término que nos permita cumplir el mandato de la resolución 26.9 que definió a este grupo de trabajo. Preocupa la aparición de otras iniciativas que puedan sustraer o desviar el sentido original del proceso, así como las pretensiones de que se avance en un resultado rápido, pero que carezca de la ambición que nos proponemos. Finalmente, ratificamos una vez más la importancia del tratado vinculante para que la pospandemia no signifique un nuevo ciclo de concentración de poder, de precarización del trabajo y de las condiciones de vida de nuestros pueblos. Muchas gracias de nuevo por esta oportunidad.
Muchas gracias, Iván. Muy importante tu contribución. Okay, now I'm going to move to English again. And I think we still have about 10-12 minutes to questions and answers. I don't know, Daniel, could you help me with the questions that may be from the chat box? I saw that there is a question for Erica, and I will read it. It says, can you explain the frustration civil society participants in the negotiations not only feel, but experience given the way the process is set up with the small time for civil society to make their points? Are we being kept in just as window dressing? Could you address this very shortly also, Erica, please?
Sure, thank you very much, Claudio. So there's been many problems related to civil society participation. And of course, we are concerned about the format of the 7th session, where we have been seeing such unequal access to vaccines in our countries. And the virtual negotiations are very much problematic for many states, especially in the global south. So one thing is we need to be sure is that civil society will not defend a process where a treaty is emptied of its purpose. So we need to continue fighting to have a strong treaty, and we need to make sure that our states in the room are also defending our demands. And we need to fight, of course, for a transparent process where we can see what are the changes that are being incorporated in the draft.
Thank you, Erica. Daniel, is there any other question in the chat box? Could you read it, please? You are muted.
Hello, Fernando. There are no questions directly in the chat, in the box chat of questions. There is one question which was referred to the conversation before. Nevertheless, in the chat, we have another one from Claudio as well, asking Ivan, sorry, there are a lot of questions now. Asking Ivan, until it's in Spanish, ¿cómo y por qué los tratados de libre comercio protegen la inmunidad de las transnacionales para seguir violando derechos humanos? Más que nada, ¿por qué? Siendo que las negociaciones son secretas.
Sí, gracias por la pregunta. Y ciertamente parte de la preocupación que tenemos respecto de esta negociación es la influencia que tienen los intereses de las corporaciones en las negociaciones. ¿Por qué? Porque los tratados de libre comercio, los múltiples tratados, la mayoría de ellos en el mundo y especialmente en América Latina, son hechos en forma y medida que garantice la impunidad y los intereses de las grandes corporaciones, que son las que se benefician de los tratados de libre comercio. Nuestros estados están de alguna manera condicionados a la presión y al poder económico que ejercen las empresas, que además limitan la posibilidad de la participación precisamente de la sociedad civil en las negociaciones, porque lo que no quieren es que se conozcan los impactos, los acuerdos y los beneficios que implica en términos de soberanía de nuestros países para favorecer los tratados de libre comercio. Lo que estamos pidiendo precisamente es lo contrario. Queremos un tratado vinculante sobre empresa y derechos humanos que sea una oportunidad para colocar mecanismos de control sobre el poder de las empresas, donde las ciudadanas y ciudadanos, comunidades, trabajadores y trabajadoras, así como los estados, coloquen también su visión. Es por eso que es importante mantener un proceso de negociaciones con amplia participación de la sociedad civil, con debates que nos permitan también colocar nuestra experiencia, incluso la valoración que tenemos sobre cómo los tratados de libre comercio constituyen un marco de impunidad para la actuación de las corporaciones transnacionales. Es el secreto, es la forma no transparente de negociaciones de estos instrumentos de comercio que nos conducen a dudar de que un tratado como este pueda ser definido sin la participación de la sociedad civil y, por supuesto, con una participación efectiva de los estados, pero sobre todo impidiendo que los poderes de las corporaciones se impongan por encima de la soberanía y de los derechos humanos, que es el objetivo del tratado.
Muchas gracias, Iván. We have also a question here in the chat box. It says, as the need of a collective initiative, what do you think about a court? Perhaps Professor Surya, could you address this question?
Thank you. Yes, I'm happy to briefly respond to this question. Yes, an international court would be, in principle, an excellent idea. But I have two difficulties. I mean, I agree with most of the diagnosis, the analysis or diagnosis of the problem that is done by other panelists. But I'm not convinced with the solution. Let us say if we create an international court, first of all, there is a lack of political will. How many states will support it? So I think we, academics, civil society, social movements, we have to create the political will in different countries first. Because ultimately, we are not negotiating the instrument, right? The states have to negotiate. So we need to push the states so that they can accept our demands. And if we are not able to do that, then we have to go back to the politics, the political process, right? So my difficulty that I see is that, first of all, there is no political appetite for an international court. Second, even if it is established, it may not have enough resources to deal with thousands and thousands of complaints. Look at the International Criminal Court, which has a very narrow mandate, and how effective it is. So if we create an international court to deal with TNCs, I very much doubt that it will be effective to tackle with these millions of companies and the rampant abuses of human rights all over the world.
Thank you very much. We have also another question. It says from Judith Lewis. She said, has any assessment of the global compact for business entities been made? Can it inform a legally binding treaty? How relevant is the ICG? Can its scope be expanded? Jesse, could you address this question?
I'm not sure if this question is for me. I'm happy to jump in. I was just responding on the chat to an earlier question from Claudia, which I realized I didn't respond to. So I'm happy to jump in on that one if it's helpful.
Yes, it's helpful.
Is that okay? Okay,
yes,
great.
Okay.
So Claudia, I realized I didn't respond to a question about whether you asked a great question about whether human rights, the issue around effective uptake of human rights impact assessments is more about stronger language in the treaty or elsewhere, or otherwise around power dynamics and the fact that the powers that be don't have an interest in essentially doing these assessments. And I think it's a great question. I think that clearer obligations with respect to these assessments can help advance advocacy pushes around these power dynamics and entrenched interest dynamics, but ultimately it is a question of in many cases political will. So I think a lot of work has to be done there. I do think that shadow assessments and increased sort of resources to engage in existing human rights impact assessment processes can help to start to undo some of those interest structures, because then you bring out some of the data around the impacts that the treaties are having, and that might help to undo some of the interest structures. But ultimately, I agree with your point. Clearer language is only really one part of the issue. One of the biggest barriers to uptake is definitely the interest structures, and those in investment governance, which is the area that I work most in, those really need to be undone. So thanks very much for your question.
Thank you, Jesse. Professor Surya, could you perhaps address the question raised before about the global compact on business entities? And there is also a question on tax, how these new agreements on tax are going to affect the business application of the human rights in the world, because the taxing rights of countries are going to be limited or in some way, and perhaps it's going to affect the capacity of a state to respond to their obligations in human rights. Could you comment on this, please?
About the Global Compact first. I think the Global Compact has done an internal assessment to what extent the Global Compact participants are implementing the 10 principles. And I think the results are quite, I mean, they look impressive in terms of making a commitment. But most of those participants are not implementing those 10 principles. So they're very weak in practice, which is consistent with what we saw also in relation to UN guiding principles. So all the businesses make commitment that we follow the principles on paper, but in practice, the implementation most of the time is weak. And I think that's why it was interesting that I think it was last year or in 2019, perhaps last year, that the executive director of the Global Compact made an open call that they are in favor of mandatory human rights due diligence. So I think that is a progressive step. So I think that is a response to that question. About the role of trade and investment agreements, I already posted a link to the recent report of the working group that may be useful. About the tax treaties, I'm not sure about the nature of the question, but the point I was making about the tax agreement is that recently 136 countries agreed that there will be a minimum tax rate. I was using this as an example of a collective action. Otherwise, what happens is that some states have this temptation to create a tax haven, that we will attract the investment and let us don't charge any tax at all. That is not the way to go forward, in my view. States should collectively agree and create a global level playing field. And if they act collectively, they are in a better position to deal with powerful companies. So they should protect their interest better, and they should have governance not only to protect investment, but also their own people. Because why do we need investment? We don't need investment for the purpose of investment. We need investment to create an inclusive and sustainable society. And if investment is not achieving that goal, what is the point of attracting such an investment? If it creates conflict, if it displaces indigenous peoples, what is the point of attracting such an investment? So I think we need to go to those fundamental questions in my view. Thank you.
Thank you, Professor Surya. We have some comments in the chat box, but we are almost done in terms of time. So I'm going to ask one of each of our speakers 1 minute to closing remarks, and we are going to finish with it. Perhaps we are going to start with Ivan Gonzalez. Your last minute, Ivan, before closing the meeting. Thank you. Go ahead, please, Ivan.
Muchísimas gracias de nuevo por la oportunidad. Y yo voy a centrarme en el último comentario del profesor Surya. La voluntad política es una respuesta colectiva, porque no es posible una respuesta individual, bilateral ni nacional frente al poder de las corporaciones. La ambición política es el llamado de los pueblos del mundo que sufren por el abuso del poder. Panama Papers, tratados bilaterales de inversión, tratados de libre comercio, lo que han demostrado es que no desarrollan, permiten la evasión, no avancen los derechos. Por lo tanto, necesitamos un instrumento vinculante como expresión colectiva del deseo de las naciones por defender a sus ciudadanos y al propio planeta. Entonces, la ambición política es fundamental de nuestros gobiernos, y nuestros pueblos reclaman que esa visión centre en la soberanía y los derechos humanos las negociaciones por un tratado vinculante. Muchas gracias de nuevo.
Thank you, Ivan. Jesse, could you wrap up? You have a minute to concluding remarks. Jesse?
Sorry, my connection dropped. I didn't hear you call me. Thanks, Luis. Just to say thanks so much for having me. I'll pick up on an additional point that Claudia made in the chat about political will. I think most of my work in this space is on the interaction between human rights issues and investment governance. I think when it comes to investment governance, where reform or redesign of the regime has been much slower than all of us would like for it to be. I think maybe political will is not the right word, but the political barriers to reform there have been significant. So I think figuring out how to undo entrenched sort of interest structures in that space is critical to addressing some of the issues that we've been talking about here. So maybe I'll just conclude on that point, and thank you again for having me and for all the reflections that were shared by speakers today. Thanks.
Thank you, Jesse. Manja, could you give us your last comments in 1 minute?
Yeah, thank you for this conversation. It has been very informative. And I would like to comment on the international court. Actually, the global campaign is pushing for an international court. This is to ensure independence of persons for the adjudication of cases. And we recognize the challenges that Professor Deva mentioned, but still, we still believe that that an independent international court is better than a committee that is also whose membership is assigned or appointed by states themselves. We also have heard that there is a move to come up with a framework convention, but we believe that this is a move to undermine the negotiations for a binding instrument, and we hope that states who are members of the South Center will not support this framework convention, but instead push and support the process for this negotiation of the binding instrument. So we are open for further dialogues and conversations, and we hope that everyone will also be open to talk with us even after this event. Thank you.
Thank you. Thank you very much. Erica, you have 1 minute, your concluding remarks.
Thank you very much. My concluding remarks would be perhaps on the issue around the need to stay vigilant in terms of which actors are actively influencing the shaping of this future LBI. We need to make sure that the future Friends of the Chair group includes some of the progressive states and the states that have been really focused in ensuring that we have a strong and effective treaty at the end. Which also talks a lot about the fact that the process of negotiation and the implementation of the future treaty needs also to be protected from corporate capture, to ensure that it's the people's demands that are at the center of the process of negotiations, similarly to what we have seen in other processes at the UN, such as the Framework Convention on Tobacco. So we need to make sure that the voice is being heard and being followed by the intergovernmental working group need to be pushing for a strong and effective treaty and not derailing the process. Thank you.
Thank you very much, Erica. Professor Surya, your concluding remarks, 1 minute.
Thank you very much. This was a very good interactive webinar. I would say the role of the civil society going forward is very critical in international norm making and implementation, in my view. So we should keep pushing the states definitely to achieve those goals. At the same time, I would say that we should not be over ambitious and hope that this one treaty will achieve everything. We should try to also be making a calibrated judgment that what are our red lines and accept this treaty as a starting point. Perhaps we need more than one instrument to deal with very difficult regulatory targets. Thank you very much.
Thank you very much, Professor Surya. I think from the side of South Center, what I can say is that we have in face of us important challenge as an opportunity as well. We will be following these negotiations very closely, and perhaps we are going to work with you all to see how we could improve the developing countries' participation as well from other colleagues from civil society organizations. Thank you very much for your participation and have a nice rest of the day. South Center, well, thank you all of you, participants and panelists. Thank you very much.